Thank you, Mr. Speaker. Will the sponsor yield for some questions?
Mr. Dinowitz?
Yes.
Mr. Dinowitz yields, sir.
Much appreciated. Thank you very much. This bill says a tenant has the right to, let's see, rebuttable presumption. You'll have to, excuse me, what exactly is rebuttable presumption in favor of hardship? What does that mean?
It means that when a tenant files a hardship declaration, that the assumption is that it's valid, but it can be rebutted by the landlord. The landlord has the right to go to court to try to stop it, to defeat it.
So in layman's terms, that would mean that the tenant is presumed to not have the ability to pay, and in that case, before the court, the housing provider would have to prove that that tenant doesn't have any money. Am I getting that right?
Well, I wouldn't put it quite like that.
How would you put it?
If the tenant signs a hardship declaration, there are a list of things that could be the justification for the hardship form, the hardship declaration, and then the tenant signs that form, and it says very clearly, unambiguously, and specifically on there that basically they better not be lying, that it's like they're swearing to it.
Okay.
So that's taken as being valid. There are a lot of things that in the law that is like that. Okay, so the hardship declaration, tenant signs it. If the landlord believes it's not the case, the landlord can try to overturn it. The landlord can go to court and say, no, the tenant's lying. I know the tenant's working. I know they have a great job, and so on and so forth. So the landlord has the right to contest that, and if the judge agrees with the landlord, then it's overturned, and the tenant does not get the eviction moratorium.
Okay. Do you anticipate that would be a pretty easy process for a housing provider, or as you put it, a landlord, which I think is an inaccurate term, but...
Okay, well, whatever terminology you would like. I'm sure no process is particularly easy. I know that when tenants go to housing court, it sure isn't easy for them. And so many things in court aren't as simple as we would like it to be, but the landlord has the opportunity to say, this is not fair, this is just not the case, and judge, please don't allow this hardship declaration to be validated.
So since you asked, I would prefer that we call them, we could call them supporters of governmental systems or housing providers. That would be great for me, because they're taxpayers. They own property that is staked right to the ground here in New York State. They're essentially renters for us, and we demand our rent every year.
You can use whatever terminology you feel comfortable with.
Thank you.
The assumption here that every landlord or small homeowner or provider of housing is a hardworking individual, the implication of that is that tenants aren't hardworking individuals, and most tenants are very hardworking individuals, some who have to work multiple jobs in order just to survive.
Through you, Mr. Speaker, if I can continue, I didn't mean to imply that, and I don't think I did in any way, but moving forward, I would like to drill down a little bit on hardship, since you brought it up and since it flows really nicely here, because on page 22 of your bill, if I'm reading this properly, number 5, moving expenses and related difficulty in securing alternative housing make it a hardship to relocate to another residence. Am I reading that right?
Well, you did read it accurately, that's for certain. Okay. And that's always been in the bill. It was in the first bill that we passed on December 28th. It was in the second bill that we passed on May 3rd. And it's in this bill as well. Nothing's changed. That's been in there all along.
So the natural follow-up question to that would be the obvious one. Is there ever a scenario where a tenant would be evicted and not have to have relocation expenses or hardship finding new housing? Does that scenario
exist? It says here moving expenses that make it a hardship. If the tenant is able to move and it's not a hardship, then that would not qualify. This very specifically says that the moving expenses make it a hardship for the tenant.
Okay. And so that you can help me understand this before we vote on this bill today and help the judges understand in the future, what would the bar for that be? Would it be $20 in moving expenses?
I think that would be up to a judge to determine if it's adjudicated by way of the landlord contesting the hardship declaration.
There's no bar or any kind of example here that you could give me that would give judges a little bit of suggestion?
No, I think judges are judges because they have to make decisions.
Well, again, and I'm not an attorney, but wouldn't that be unduly vague in the court's eye?
A lot of things are vague, you know. There are a lot of words in the law that you might think are vague, but I think you know, we use the standard of reasonableness in these cases, but I think the word hardship, that's a pretty definitive term.
Okay. And through you, Mr. Speaker, how will this bill guarantee due process is extended to our housing providers here in New York State?
Who said there's no due process?
Are there any guarantees that due process will be extended to housing providers in New York State?
The landlord has the right to go to court. They can file a motion on anything they want, just like anybody can. There's nothing special here, nothing more, nothing less than what they would normally be entitled to. And there's nothing that's written here that says landlords have due process. Everybody's entitled to due process, period.
How long did this bill take to write?
I believe that this bill was worked on for quite a while, actually,
Is there a reason that we didn't see it until 2 p.m. today?
because it wasn't finalized till very recently. You know, a few things may have changed in New York in the past week or so. I think you've probably noticed that. We have a new governor. She got behind the idea of doing this. In fact, yeah, that's right. This is actually a bill. It's called the Governor's Program Bill. This is her bill. I mean, I've had legislation that we were trying to develop over the past few weeks because I knew that the August 31st date was coming up. It didn't just dawn on me on August 30th to try to address this issue. And we knew we had to do two main things in terms of the previous bills. One is we had to have a new date in the future to extend the eviction moratorium. And secondly, we had to make sure that due to the Supreme Court ruling that we added additional language that made sure that landlords got due process and that it would be bulletproof from being overturned by the conservative majority on the Supreme Court.
I appreciate it. One of the things, through you, Mr. Speaker, one of the things that I noticed about this bill that I didn't necessarily, and you know, it leads right into what I view as a lack of government transparency when we don't air out legislation with enough time to review. But that there is a section on open government included in this legislation, which, you know, I'm always open to looking at these things, and I think it's great that the governor has brought something forward in a program bill. The Committee on Open Government actually wrote a report to the legislature and the executive in December of 2020, specifically with a target on what local governments should look like post-pandemic and how we might handle that. Have you reviewed that report?
Well, first of all, I'm going to turn it over to Assemblyman Zabrowski, but this bill deals with a very specific and narrow issue, which Assemblyman Zabrowski will talk about.
Mr. Zabrowski.
Thank you, Mr. Speaker. Sorry, Mr. Walczyk. Go ahead. Maybe I can answer your questions.
That's fine. I'll ask it again. The Committee on Open Government in December of 2020 wrote a report to the executive and the legislature outlining some guidelines for what they thought was a good suggestion for how we may proceed with open government legislation in the future. Had you reviewed that report?
The Committee on Government Operations works with the Committee for Open Government, so we review everything that they submit to us. This specific section has to do with allowing municipal and municipal type entities, you know, authorities, local authorities and things like that, the ability during this current surge to, if they want, it's at their option, to conduct their meetings remotely.
What did you think of the Committee on Open Government's suggestion for the legislature to do a complete review of what local governments had done during the pandemic?
During this debate, I think what's prudent is for me to answer questions related to this section that's in this bill, but I'd be happy to discuss other issues or other bills with you at another time.
Sure, understood. Why is specifically to this bill, why is the open government portion only effective until January 15th?
Well, this pandemic, unfortunately, has ebbed and flowed. So we had to come up with a date by which it would make sense to perhaps re-review whether or not this was appropriate. So January 15th seemed like as good a date as any for us to, if we needed to extend it, not extend it, alter it, seemed like a good time to do that. So it's a handful of months going forward, for hopefully at that point, perhaps the Delta variant and we're back on the downslope, and maybe we could amend this, change it, or just let it expire.
So January 15th doesn't have anything to do with the timeline that the governor issues her budget, for example?
No.
Is there any fiscal impact on this section of the bill at all on local governments?
No. It's at, and I want to point out, it's at their option. So if they think there's a fiscal impact, they don't have to employ the remote option.
What feedback or refinement from local governments did you receive before this was drafted?
Oh, I've heard a lot of feedback from local governments. Most local governments that have weighed in have asked for some sort of option to conduct meetings remotely. In fact, some want us to look at how they meet independent of the pandemic, and I think myself and other colleagues have talked about that, and we intend to do that. But specific to this piece and this pandemic, local governments have contacted me personally, and I can speak for some of my colleagues who have told me they've asked them for us to enact something like this. And I'll just point out again, it's at their option. So for those that may not like this idea, don't do it.
Thank you for answering those questions on that section. I have one final question for the sponsor, if he would yield for it, Mr. Speaker.
Mr. Dinovitz, one last question.
There you are. Yes.
It's really a two-parter, so apologize because I did that. I said one final question. But in your view, does this bill cancel rent?
No.
How long would we have to extend a moratorium, in your view, in order to call it canceling rent?
Forever and ever. I mean, this is not cancel rent. We don't deal with two-word simplistic slogans. We deal with things that are going to help people, both tenants and landlords. And that's not what this bill does. Not cancel rent. It very specifically doesn't cancel rent because landlords do have the opportunity to go to court to try to get monetary judgments for money owed to them.
Thank you, Mr. Speaker.